right. Good morning, everybody. How are you guys doing? So I'm going to start a little bit random with you guys, and I'm going to start talking about British monetary policy. Okay. So if you are not aware, back in the 1600s, 1700s, England was used a gold coin called the guinea up until about the mid or early 1800s, and they switched to the pound. And even when they switched to the pound, they kept the guinea around. Okay. So the pound is worth 20, even today, the pound is worth 20 shillings. And the guinea is worth 21 shillings, right? And some of you are nodding in agreement. You probably know where I'm going with this. Okay. So the guinea is worth 5% more than a pound. It's worth a pound and 1 shilling extra. And it's still used today in the sale, in the purchase and sale of certain luxury goods. And in the world where I come across this, it's in horse racing, because when I'm not acting as a lawyer, I buy and sell racehorses. So when you're in England, and if you buy a racehorse through different auctions like the Tattersall's auction, you still buy racehorses in guineas instead of pounds. So if you buy a racehorse for 100,000 guineas, the actual sales price is 105,000 pounds. It's 5,000 extra. It's 5%. And when you pay that, when you buy that horse for the 100,000 guineas, you have to come out of pocket 105,000 pounds. And what happens is 100,000 pounds goes to the person who actually sold the horse, and the extra 5,000 goes to the agent, and that's the commission. So when you're buying or selling horses in England or art or anything like those types of luxury items, the commission is baked into the sales price. And they do that by still selling in guineas. By analogy, we see that same thing happen in the sale of houses in America. So today, if you have a house that's being sold for $1 million, what's built into it? It's the commissions, right? More specifically, when we talk today about this big class action lawsuit, what's built into it is the buyer's commission. So if you have a house that sells for $1 million, built into that is $25,000 or $30,000 for the buyer's commission. And if going forward, the buyer's commission's not going to be paid out of that, then that house isn't worth $1 million anymore. It's worth $975 or $970. So the big misnomer going forward, and what's missing a lot from the articles that you read online, is this idea that the quote seller pays the commission, and that by taking out this, by taking out the buyer's commission, the house is still worth $1 million, and that the seller is going to save all this money. And that what really is going to happen going forward is things may change. There may be different disclosures. There may be different rules. There may be a different allocation of costs. But the biggest thing that we need to understand going forward is it's just shifting who pays what when. Because at the end of the day, the house is still worth $975, and commissions are still to be earned by the buyer's agent and the seller's agent. And you just have to figure out who pays what when. But the value of the house didn't just become worth $1 million to the seller, and now all of a sudden the buyer's got to pay $1,025,000 in order to pay the agents. The house is still worth the same, right? The house is worth $950,000, and the listing agent gets a commission on top of that, and the buyer's agent gets a commission on top of that. And so we'll sort through the lawsuit, but the big picture thing that I think everybody needs to understand is the house is worth a certain price, and then there's commissions baked in on top of that. And you can include that in the sales price and then deduct it from escrow, or you can have a flat price for the house and you can add commissions on top of it, or some combination in between. But the house is worth the same, no matter what. And then the commissions can come out of the deal or can come on the side, right? Or come on top after the fact, or however you want to do it. But it doesn't mean more money for the seller just because the buyer pays their own agent or the buyer doesn't have an agent. And I think that's the thing that gets lost in the translation. Okay. So some nuts and bolts for those of you that may not know as much about the lawsuit, so that we all kind of start in the same place. I'll talk about the lawsuit itself. So the case that went to trial was called Sitzer versus the National Association of Realtors. And the plaintiff that was there was Joseph Sitzer. But really, the plaintiff was probably the lawyers, right? Because when a case goes forward on a class action, it's mainly being driven by the law firms that take these cases. And the plaintiffs are really the nominal people that sign up to be the class action plaintiffs. The plaintiff, the named plaintiff in a class action case gets a nominal amount of money at the end for what their damages were, what their specific damages were in their given real estate transaction, plus a little bit more for being the named plaintiff, but they're getting a small fraction of what ended up being this $1 billion award. The defendants in the case were the National Association of Realtors and then two different brokers, Home Services of America and Keller Williams. The case went to trial in federal court in Missouri and was one of several class actions that are currently pending. So there are several other class actions that could follow this in different jurisdictions around the country. And then just so you know, as soon as this case was over and they were victorious, this same law firm filed a bunch more class actions in different jurisdictions. The period for which this class action was filed, so the period of time that it covers, was April of 2015 through June of 2022. So part of the reason the damage award was so big was because it covered all of the transactions in a geographic region for a little over 7 years. The specific issue that went to trial was what is referred to as the clear cooperation policy. So what the plaintiffs alleged, and I'm going to look down a little bit for this part so that I make sure I say this as correctly, is the plaintiffs allege that the National Association of Realtors policy requiring the listing brokers use the MLS to offer commissions to the buyer's broker was an antitrust violation because it increased the cost to the seller. The plaintiffs allege that the brokers conspired and colluded with the National Association of Realtors, and that it's an antitrust violation because it resulted in higher commissions than would have resulted without this policy. Now, implied in that is that without this policy, there would have been lower commissions because the buyer's broker would have either received less or no commission without this policy being in effect. In defense of this case, NAR and the brokers argued that the rule that's in place is that there is no requirement that the seller offer any commission or could offer a lower commission, that it's negotiable in every transaction, and that is disclosed to the seller in every case. And that the clear cooperation policy is just used to make things simpler and to, it's the custom in the jurisdiction, but that it is not required by any seller. And it's just for ease of the transaction. And that without this rule, it's confusing and cumbersome to try to figure out what the commissions are going to be in every transaction. Now, the jury deliberated for a whole 3 hours, which is less than a football game, and decided that the plaintiffs were entitled to $1.78 billion. There's going to be a second phase of the trial where the judge could award treble damages, which is up to 3 times the amount because it's an antitrust violation. And the plaintiffs are also asking for an injunction, which is a bar to using the clear cooperation policy going on and going forward into the future. All of the defendants have said they are going to appeal this award when it becomes a final judgment. In order to appeal, they may have to post a bond, and a bond is usually 150% of the award, which means in order to appeal, they'd have to come up with close to $3 billion, which may or may not be financially possible for these defendants. If it does get appealed, it will take years before it's finally resolved. I don't know what the backlog is in that district, right? But in our district, it would take about 2 to 3 years before you got a case heard on appeal. So it's not near resolution if it goes through that process. From what the articles say online, none of the defendants can afford to pay this award if it actually, if they actually lost on appeal. But at any point in time, the case could settle. Most of the time, right, what lawyers want is they want money. It would be nice. The lawyers are, arguably want the rules to be changed, but at the end of the day, the lawyers are there to get paid. So the case could always settle for a fraction of what the award is, and some rule changes. And I'll talk about what possible settlements could be going forward. So before I go any further with what could happen or what the rule changes could be, does anyone have any questions so far? Yes, sir, but you got to run up to the mic.
Hey, Lee, can you turn it on?
Oh, thank you. Hi, Tony. I'm Lee with Great American. I got a question for you. My reading indicated, the readings that I was doing was there was a deceptive piece in their listing agreement. Could you address that? What was the deceptive piece? That the sellers didn't know that they were going to pay the other agent money, commission?
Right. So the way the decision gets handed down is the decision doesn't deal with any specific piece. It deals with the overall rule and says generically the entire clear cooperation policy in itself of the requirement that NAR has of just generally requiring the listing broker to put a commission amount in the MLS itself is an antitrust violation, right? And that in and of itself is what they have found to be damaging and to be an antitrust violation and what may be enjoined going forward. So they don't get into the specifics of any one type of thing. They say the entire rule itself is an antitrust violation. And that's why it may affect nationwide, because that rule is nationwide through the MLS. Yes.
So my name is Lily from Maxreal. My question is on our car form, is Pacific said is a negotiable commission, and they have the one line say how much you pay to the buyer agent. It's very clear in the California, the form. So do you think it affect California?
So that was the defense. So that is why the real estate industry is upset at the decision, that was the same defense that was made in the case in Missouri, which was the rule is that this is negotiable, and the jury said it was still an antitrust violation because the way it's kind of pushed down the sellers. And that's the piece that is deceptive. That was argued, the plaintiffs argued was deceptive, is that it's pushed onto the sellers that they have to do this. Right. And now you could get different decisions in different jurisdictions. All right. I mean, those are the types of issues that are going to have to play out in different jurisdictions and play out nationwide. Right. But that was the argument that NAR made, is that the rule is that it's negotiable.
So exactly what state is this? This is going to affect the whole country. Is this in New York? Where did all this happen?
So it happened in Missouri, and it affected the federal circuit out there. Right. So right now it's essentially the Midwest.
Okay. Thank you.
But it's coming. Right. Because as soon as this award was issued, they then filed lawsuits in all the other jurisdictions,
Including California,
I believe,
regardless of
California.
our own car forms and so forth.
Right.
Okay, thanks.
All right. Yes.
So what do you think is the future of California real estate?
That's
in
the
your
next,
own?
the next 30 minutes I'm going to give you.
Okay.
All right. So why is this important? right? It's important. It impacts sellers because a lot of people think, and I quote, I quote, I put think in air quotes, that sellers pay commissions. So the idea is that if with this award, with this rule, sellers will pay less in commissions because sellers can opt to say, don't put that in the MLS, and I don't want to pay the buyer's commission. And by doing that, I will then pay less to the buyers. I won't have to pay the buyer's agent. So when I sell my house for this mythical $1 million, then I will get more net proceeds. To the buyer, it's important for a number of reasons, right? Starting with buying a house is probably the biggest purchase a buyer will ever make. They invest a lot of money both into the purchase price, and also into the down payment, and into the, a lot of times the mortgage payment that they will make monthly will be the biggest monthly expense that they have going forward. Also, it's probably the greatest way most people accumulate wealth going forward is the appreciation they expect to anticipate in the growth of their house. A lot of times they will not have the ability to pay their agent. So where the simple answer is we'll just have the buyer pay their agent on, separately. They will, they put all their money into their down payment. They may not have that extra. If they pay the $1 million for this house, they may not have the $25,000 or $30,000 extra to then also pay their agent. So they may then go unrepresented in the biggest purchase that they're ever going to make, where a transaction has hundreds of pages of disclosures that they need to read in order to buy the house. So it could have potentially a tremendous impact on a buyer making such a significant purchase. So what's the potential impact on these types of transactions? What are the options that exist? And in no particular order, one option is buyers go unrepresented, right? Well, one advantage to that is articulated is that saves the seller money. I guess that's good for the seller. But I would argue that's arguably not true. And that was the purpose of the analogy I started this with, which is, and there's two different ways to look at it. I'm going to stay with that same example of $1 million, even though I know you may not be able to buy a house for $1 million, but I use that because it's a good round number to work with mathematically. So you have this $1 million house. One argument is the buyer's not going to offer $1 million anymore. The buyer's now going to offer $970 for that because the buyer's got to pay their own agent. That's one argument. The other argument is, why does a seller presume that the listing agent is now going to take a listing for 3%? Right? Why wouldn't the listing agent still take the listing for 5 or 6%? Because coming forward, the listing agent, at the time the listing agent takes the listing agent doesn't know the listing agent may not be a dual agent, right? The buyer may come and say, I want you to represent me. And the listing agent says, well, if I'm going to double end this and I'm going to have the risk on both sides of this, I still want the full commission. I'm not going to take the listing at 3% and still get stuck being a dual agent and have all of the risk for half of the money. Right? So at the inception, the listing agent may still want the listing at 5 or 6%. That's one thing. The listing agent also has to worry about what happens if the offer comes in and says the offer comes in as $1 million, but the seller still has to pay a 3% commission to the buyer. Now, what's the listing agent do when he or she already has a listing that's at 3% now? Go back and amend the listing agreement? Right? So the easiest thing for the listing agent to do is say, I'm going to take the listing at 6% and we'll see what happens, what comes in with the offer. And if the offer comes in with not asking for a buyer's commission, then we'll change the listing commission and what I get paid. Right? So the supposition that right off the bat, the seller's only going to pay a 3% commission may be flawed at the premise. The disadvantages to the buyer being unrepresented are many, right? One flaw in that is like I talked about already, is that you have a buyer that's being unrepresented at the biggest purchase of its life. which I guess may work out great for me and people like me, is I would imagine that's going to result in a tremendous amount of litigation if buyers start buying houses without agents. But there's another flaw that I saw get mentioned in a series of articles that doesn't get a lot of press, but has been mentioned a couple of times, which is there are genuine safety concerns, right? Right now, when you have real estate agents, they serve as a screen to people, right? Agents go show property to people and they tend to be with the person when they're seeing the house, or there's open houses and agents are there at the open house. But if there's no buyer's agent involved, who's screening seeing the house? So if some felon wants the access to your house and you've now, you've listed it with the listing agent, but there's no buyer's agent, who's there to act as a screen to who gets entry into your house, right? So if some thief wants to just start going through houses, who's there to act as a screen to it? Or if, like for physical safety as well. So, I mean, agents serve that purpose as well. And that goes away if all of a sudden any random person just starts to have access to houses. So that's one. One option is buyers go unrepresented. The second option is buyers use attorneys instead of real estate agents, right? This also saves the seller money, arguably, because the seller's not paying a buyer's commission. But this also has certain flaws for the buyers. As an attorney, I do real estate deals for people. And I am in our area, I am cheaper than using a real estate agent. I charge on average $5,000 to $6,000 for me to handle a transaction, right? But I come with several handicaps. One, I can't offer an opinion as to value, right? I have no idea how to do comps. I have no idea how to appraise a property. So if you come to me and you tell me, hey, I'm willing to pay $1 million for this house and I'm comfortable with the price, I can draft up the contract for you, but I have no idea if you're getting ripped off or if you're overpaying. Right. So, I mean, you need an agent or appraisal for that. So if you come to me with that, the first thing I'm going to tell you is I'm going to give you kind of a CYA letter that says you've determined the value is fair or you're comfortable with it. And if not, then you should go hire an agent or an appraiser to give you an opinion as to value. The other thing is I don't have a network or team of people to do inspections. Right? I mean, I'm going to either tell you to go to the internet and, do your own inspections, or I'm going to go on the internet and find people. But I mean, I have no idea who should do a property inspection. I mean, frankly, I know you should do a home inspection and a termite inspection, right? But I mean, I don't know what other types of inspections you should do, right? I mean, I can draft the documents, but that's pretty much what my expertise is limited to, right? So you're getting a smaller skill set when you hire an attorney. The other thing is, depending on what jurisdiction you're in, you may or may not be saving money by using a lawyer, right? If you buy a $3 million house, yeah, using a lawyer is probably cheaper. But if you're buying a $400,000 house where your commission is going to be 10 grand or 8 grand, you may not be saving that much money by using a lawyer. So the transaction cost may not be that much less. Third option is what in the literature they're referring to as decoupling. And that is where the buyer pays their own agent. And again, this has the same benefit. You'll see a theme. This has the same benefit, alleged benefit to the seller. The seller doesn't have to pay the commission. One disadvantage is it's probably unrealistic because there's going to be a big pool of buyers that don't have the extra money to pay their own agent. Right? Once they've come up with the down payment, they're not going to have this big pool of cash sitting there on the side where they can also write a separate check to their own agent. I mean, some will be able to, but I think that is going to be a smaller percentage. And, at least as of right now, our system is not set up for your loan to finance your payment of a commission. So what would probably happen is, buyers, one option is buyers come in with a smaller down payment or a smaller deposit and then use that money instead to pay their agent. So for instance, on that $1 million deal, instead of putting down a 3% down deposit, you put down a $5,000 deposit and say, I'm using that $25,000 to pay my agent. Or you make an offer where you build it in and like, even though the MLS doesn't sit, even though the MLS doesn't offer to pay the buyer's commission, the buyer's agent commission, you put that in your offer anyway. Right? So the house is listed for $1 million. You come in with an offer for $1 million conditioned upon you paying my agent 3%. Right? There's nothing that bans that under the law. You can still make that as a condition of your offer. The fourth option is a ton more dual agency, which is, so you're just by not offering a commission to the buyer's agent, you're just driving more people to the listing agent, which is counterintuitive for two reasons, because there's number one, you have, well, I guess it's the same reason, but two different people. I mean, you've had the DRE and the Department of Justice for years, sending indications that they want to get rid of dual agency. Right. And now you seem to have a policy that's going to drive buyers to the listing agent because you've taken away the mechanism to pay the agent they wanted to hire in the first place. So it seems like you have two policies running in contradictory directions right now. And then the fifth option that I've seen mentioned is having the listing agent offer to pay the buyer's agent as a referral fee, which just seems to be the same thing under a different name. Right. And so instead of doing it ahead, whether you do that ahead of time or you do that as the offer comes in under a separate agreement, you've just changed the name of the document, but you've done the same thing. So it's almost a way of just kind of skirting the rule. And then the last option would be, and I kind of indicated ahead of time, is you just have a buyer come in and make the payment of the buyer's agent commission a term of the offer. And it seems that the quote experts in the industry seem to think that that is probably the most likely thing that would happen, because it's a way to stay the same. Even though it's not put in the MLS, it's just, you're just negotiating the commission on a transaction by transaction basis. So going forward, right, in getting back to where we started and getting back to your question, your point actually is the rule here in California is that commissions are negotiable, and we would just have that on a transaction by transaction basis. So one option may be the sellers put in the listing agreement, or the sellers put on the MLS what their indication is. Some sellers can still offer, some sellers can still offer buyer's commissions through the MLS. Some sellers can be silent and offer nothing. Some sellers can indicate on the MLS they refuse to pay a buyer's commission. Some buyers, if the sellers are silent, if the MLS is not offering a commission and they're not taking a position one way or another, the buyers can either pay their own agent on the side separately through a buyer's agent agreement, or they can condition their offer upon the payment of the buyer's agent commission. Right? Those are right? And then every transaction can be different. You're just, instead of having a policy in place ahead of time, you're doing it on a transaction by transaction basis. But I think I think kind of what lesson number one of the day, if I could communicate anything, is the idea that the sellers pay the commission is flawed, right? There is one pot of money, and all of that money is provided by the buyer, right? The buyer puts up the pot of money, the seller distributes it, right? And for the seller, at the end of the day, the only thing that matters is what is the net proceed to the seller, right? And I think as a listing agent, if we're going to shift to this world where it's a transaction by transaction deal to determine what the commissions are, and you may get some offers that offer to pay so you're a seller and you've decided in my MLS listing, I'm not going to offer a commission. I'm just going to be silent as to what the commission is. You know, we're just not going to say anything. So what probably happens to you as a seller? Well, you're selling your house for, you want $1 million. Well, you're probably going to get some offers at 970 that say that, but don't require you to pay a commission. And you're probably going to get some offers at $1 million or around $1 million that require you to pay a commission. Right. And now that's going to be super confusing because there's this big delta with some of them requiring you to pay this big chunk of money. And now you got to do math to figure out what your net proceeds are. Right. Because your net proceed is that's the big deal. Right. How much do you get at the end of the sale of your asset? And now this shifts the burden to your listing agent to do a good job to figure out, well, how do you compare the offers that require you to pay a commission to the offers that don't require you to pay a commission to figure out what your net proceed is and which one is better for you. Right? That's what I think now becomes the impetus on the listing agent. On the seller, but getting back to lesson number 1 is to explain to sellers, right, that the key to you is not you paying the commission. The key to you is what is your net proceed number? Lesson number 2, and for what to explain to buyers, is you've always paid the commission. This isn't something new, right? The commission, like I started with, like my analogy of the sale of the horse, right? You were always buying in guineas. You were never buying in pounds, right? The commissions, the 5 or 6% was always baked into your sales price. Your pot that you were putting into the deal always included commissions. This isn't something new to you, right? This decision didn't mean all of a sudden you had to buy the house for $1 million and now pay me as your buyer's agent. It just means now you have to pay $970 and pay me $30. Right? There's a lot of articles out there that are saying, oh my God, the buyer's agent's going to go away. And you're now as a buyer's agent, you have to justify your value in order to get paid. It's like, no, you don't. Not any more so than you used to, right? All you have to do really is explain to them you're just getting paid in a different manner. You used to get paid as part of the purchase price, and the buyer paid that way as part of the purchase price. But now you just offer less, and pay me on the side. Or you offer the same $1 million and we condition it upon them paying my commission, right? And as a best practice, you probably need to use a buyer broker agreement that says, look, we'll try to get, we'll make an offer that says the seller's got to pay my commission. But if not, you owe me X, whether that's a percentage of the purchase price or a flat fee of some amount, whatever you and your broker decide to do, right? But you probably want to have some exclusive engagement with a form of compensation booked into it, right? But I think the two big lessons that you take out of this are sellers need to understand it's about net proceeds in comparing offers, and buyers need to understand they've always been the ones that put up the money that pay all the commissions. And I think if as agents and brokers, you can convey those two things, then you realize this decision, this class action decision that everybody's fretting about isn't that big of a deal. It just shifts how you do things a little bit. And it shifts maybe the timing and form of where the payment comes, but it really doesn't shift the amount of payment. As to the lawsuit itself, like what's the most likely thing? Statistically, 98% of all cases settle. It's just a matter of when. Likely result is this case still probably settles because the defendants can't afford the award and the plaintiff and the lawyers still want money, right? It may settle for a lot of money. It may settle for as much as the defendants can afford to pay, but at the end of the day, it probably still settles. It probably settles for an amount of money and some rule changes. According to the literature, we're probably likely to see NAR have to give up on its clear commission policy. And the requirements that members, be required to be a member of NAR and be required to be a member of the MLS and make those both voluntary decisions by realtors. But at the end of the day, you probably see a settlement along some of those terms. So that's it. That's my pitch as to what I think the options are for agents going forward and how I think the case settles, and what ends up happening. And I wanted to make sure to leave at least 15 minutes, 20 minutes for questions, because I'm assuming there's going to be a lot.
No, you did a great job, Tony. Why? I mean, wasn't that good, you guys? Yeah, so I just wanted to kind of confirm what you heard Tony say. I'm your NAR director. I'm one of two for SCORE. So I go to Washington and hear all this news. And I'm one of your CAR directors at the state level as well. And the last thing that I am is one of your MLS directors. So as a result of all this, we also have to make some MLS changes if some of this stuff happens. What I want to let all of you guys know is don't stress. Take a deep breath. Things are going to move forward. Right now, the way I see things and from what I've heard from everybody, our biggest change is going to be the use of a buyer broker agreement for all of our transactions. Wow. We can do this, guys. We do a listing agreement. We're just going to do a buyer broker agreement. No big deal, to make it very clear to the buyer where that commission is going to come from. Does that make sense? Now, because of the way we do things in California, our risk is less, is what everybody's told me. But, lawyers want money, and they know California has way more money than everybody else. But as far as I could see, you guys, business as usual. At the NAR level, we are going to fight this tooth and nail. I mean, my understanding is the majority, if not all of those people that heard this case were renters. None of them owned a home, never gone through this process. I also heard that there was no way in heck you could have read through all the documents NAR submitted. I'm not kidding. Reams and reams of documents taller than me, that would have taken a month for a jury to go through, and they did none of that. So there's a lot of things that are wrong with what happened, and we're going to fight this. So roll up your sleeves, smile, do the good work that you do, and life goes on.
Yeah, you got to go up to the mic though.
Of course not. Of course not. First, great presentation.
Thank you.
Thank you. A couple of comments. One, let's talk about the buyer broker agreement for a minute. Is it even worth the paper it's put on? And I say this in a polite way. My question is, I have a buyer broker agreement. A lousy mic. Somebody tries to back out of the deal. I go to my broker because it's really to my broker. It's in my broker's name. Is my broker going to stand behind it? Probably not. My question is it's just a waste of time doing these buyer bro? Is it worth the money? And is it worth the money the paper's put on? I mean, is it worth anything? It sounds like it's nothing.
So there's a bunch of questions. There's a bunch of questions wrapped up into that.
Yeah.
So the first question is, the first part of that is like, is it enforceable? Right. And the answer is yes, it's enforceable. Right. The second part of that is like, is it financially worth it to sue?
The answer is no.
Right.
Probably.
And then, the answer to that is it depends on the deal. Right. If it's $1 million house and your commission's going to be 30 grand and there's an attorney's fees provision in it, right, then it depends, are you and your broker willing to spend the money up front to go after the commission, knowing that you can get your attorney's fees back if you win, right? That also then depends also on, did they end up buying the house through somebody else, right? Because that also then becomes a lot easier to prove versus did that buyer get out of the market because they couldn't afford anything, right? Because if you came to me and they bought the house and that asset is sitting there and it's easy to collect upon, that would make me more likely to want to do it. Plus, the third part of this is there's this backdrop now of, don't brokers have to send the message they're going to enforce these things?
Yep.
Right? I mean, isn't there a sea change now where because you're not getting paid out of the, out of the MLS like you were in the past, don't you as an industry have to enforce these and make these like listing agreements? Right? So, I mean, I think there's a lot wrapped into
I
that.
think you're right. And I think also isn't it kind of anti-consumer? I mean, like right now, I'm just curious, how many people have actually used a buyer broker on a regular basis? Probably not a whole lot of people here. Now we're going to force the buyer to sign an agreement that says you're stuck with me, whether I'm a bad agent or good agent, for the next 3 years. That doesn't seem,
So I will tell you as a lawyer,
yeah.
I never understood why the custom was not to use them.
Because we never had to. If you're a bad agent, people are going to fire you, and that's fine. You're a bad agent.
But I mean, I'm
But-
just saying it always seemed counterintuitive to me
Yeah.
to not have that.
Okay, another question. The NAR lawsuit, let's talk about that for a minute. And this is an opinion because you weren't involved in it. Did NAR handle it properly? Did they do a good job on spelling out the problem? Because when I read the stuff, I would have to be an absolute idiot if I was a juror and I still went against NAR on that. I mean, we have so much great information about what we do and how everything's paid. Did we blow it on this one? And do you think this thing's going to get appealed properly? Oh, I'm sorry,
Yeah,
excuse
no.
me. Is the appeal going to go through?
I mean, have not spent nearly the time looking into how the lawsuit was litigated to give you an opinion on that.
Good answer. Safe answer. Thanks a lot, Anthony.
Right.
We're seeing ads in the mail already from our peers where they're saying they don't have to, as a seller, you don't have to pay commission to the buyer's agent. We already beginning to see that. So the question also, we are seeing a lot of sellers saying us, hey, we want to interview you, but we are aware of all these articles floating where you don't have to pay the buyer's agent commissions. So the question comes up is, should we be taking listings with no buyer's agent commission built in?
So that's not a legal question, right? I mean, I don't have any expertise that would answer that any better than anybody else in this room. But I have to believe the answer to that is no. Right? That you should still take the listings and you should still do the best job you can. And I think that there's just going to have to be education. You're just going to have to educate sellers to understand that the law didn't change. Right? I mean, the law is still commissions are negotiable, and you have to explain to a seller what their seller's options are. The seller has the option to offer a commission or not offer a commission, and there's ramifications to both of those options. Right.
And if you're the other thing I'm going to encourage you to do is if you're seeing mail pieces and you're seeing certain things that catch your eye and you're not quite sure, take it to professional standards, because there could also be code of ethics violations with sending those things out. So what I'll say about that is if people hate to turn each other in, but if you don't turn each other in and you have other agents doing things like this, you're potentially losing out on deals, and that person is okay to go do what they want when they want for whatever reason they want. And if you don't police yourselves, who's going to do it? And then the public is just going to continue with their thought process of what they think about real estate agents. So it's up to you guys to contact professional standards, find out if there's a case here, and hold each other accountable to those professional standards that you guys agree to uphold.
So I love that segue, because I was going to bring back the buyer broker agreement and professional standards. So as one of your professional standards presiding officers, I get to hear these cases before me. And the ones about commission, they're through arbitration. And guess who gets to hear them? I do. And guess who ends up winning 100% of the time so far of the ones I've heard? are the ones with the buyer broker agreement because it's very clear they had that relationship. So they get their commission. The ones that don't have that agreement, well, it's a toss up because there's a checklist that we have to use when we look at that. So be smart, protect yourselves, get the buyer broker agreement. All what you're doing is you're elevating your professionalism. You're telling the brokers or the buyers, here's what I'm going to do for you. And it's all in writing right here, just like you do with the listing agreement. It's exactly the same thing for the buyers. In my opinion, it makes all of us look a lot more professional.
And I got a question on Zoom I'm going to ask. Since the buyer is paying for both the listing and the buyer's agent's commission through the purchase price, currently buyer's agent's commission is transparent. Can the buyer ask to be transparent for listing agent's commission and reduce it totally from the purchase price? I feel like that was a loaded question.
The answer is no, because the buyer's not a party to that contract. That contract's between the seller and the seller's agent, so they're not privy, they're not in privity to that contract.
My question kind of goes back to the same thing. When the buyer buy the property for $1 million, he pays property tax on that for the rest of his life. Did the lawsuit have anything in that situation?
Not that I'm aware of.
Because this buyer broker agreement concept is new to a lot of people, it's not just about understanding the contract and having somebody sign it. If you made a list of every single thing that you did, you're not working for free. And the other thing is, buyers are asking you how much you're making. Do you walk into Starbucks and ask the person behind the counter how much they're making? Do you do that? But they're coming to you to find out how much you're making. You're earning a living, you're working. And right now they're going to question everything. So you need to be able to speak to that contract and say, yes, I'm making X amount of dollars, but I'm not selling 4 houses a year. or 4 houses a week. I'm sorry. And I'm not getting, and I'm using number sake, I'm not getting 6% on every single one of those houses. So no, I'm not making $4 million a year. Because how many times do you guys hear, oh, real estate agents are rich? Can you raise your hand if you're rich in here? I didn't think so. Oh, we got one. So it's about it's about your worth and your value. Again, you guys are in an industry where people are asking you all the time, how much are you making? And that's kind of, you got to be able to speak to it. And Mark, if you don't want to get that signed, then you do all that work for free. And then I'm sure somebody else would love to come behind you and just take that listing from you because you didn't get anything in writing. So everybody knows Mark doesn't sign it now. So let him do the work and then y'all can sell his houses.
I just have I would envision that there's going to be a lot of dual agency because there's a lot that happens now. You have a listing and buyers are contacting you. Can you represent both parties, right? So in this scenario, if you're representing both parties and the seller does not want you to represent both parties, which does happen, right?
Right.
And it's not you're not agreeing to that. At what point a buyer represents themselves and they come to you and they want to write a contract, they're wanting you to provide them a contract. They're wanting you to do this and this. At what point do you have to draw a line that you're not crossing over the representation? Now I'm representing the buyer, not getting compensated, but they will come after you because who are they going to contact? They're going to contact the listing agent.
So that's a funny question.
Is it?
Because so my wife's a real estate agent.
Okay.
And we have this discussion all of the time because I am amazed at the level of work that you guys will do without a buyer broker agreement in place. Because in my line of profession, you can't even get me on the phone until you've signed a fee agreement.
Okay.
Right? Like I do not give out any free advice. Because that's all I have. All I have is my intellectual property, right? If I start answering questions for free, then you don't need me.
Okay.
Right? So the fact that you guys would do anything without an assigned exclusive listing agreement or buyer broker agreement doesn't make any sense to me.
Okay.
So my answer to your question is the first phone call. Right? That's an interesting question. Sign this agreement. I'd be happy to answer it for you.
Gotcha. I just want to make a comment also is that I could see that if somebody's paying no commissions and they're reducing the price and the commissions are being paid on the higher end homes, there could be a big delta and appraisals could really come into an issue if one is not paying the commission and they're reducing the price. And now you've got somebody who's paying, right, on a $3 million home. I'm just making that comment, right?
Oh,
Where
no,
the comps could be
oh, yeah.
running into an issue also.
Right. No, and the other part that could introduce a bunch of chaos to this is if like the Department of Justice comes in and says there's no more dual agency.
You know, a couple of the questions, my concerns, because if this,
Those are two different things.
okay, you're bad. First question. Is there concern that agents are going to start, well, they're accusing us of steering right now. They're accusing us that we look at the highest commission and then we go, we show our clients that higher, more expensive deal than the cheaper ones, which I don't think is true. But that's what they're saying. Now, if we go with zero commissions, are we going to be accused of steering people away from those deals? Is that going to be an issue, I guess? Do you see
I
that?
mean,
legal
sure. I
case?
mean, sure, it could be an issue. I mean, especially if you don't have a buyer broker agreement in place.
Yeah. Okay. Second question is, great, you answered it. Is there a kind of conflict of interest also in the sense I'm representing my buyer? And maybe he's not going to pay me. Well, he's not paying me a commission. He wants me to make sure that the other person pays the commission. I put in my offer, Mr. Jones, this is our offer price, but you're gonna have to pay me $30,000 or $50,000. And he says, no way. Now, I have a due diligence to protect my client. Is there gonna be any conflict on that saying, hey, guys, they're not gonna pay me. So, you know, my commission comes over your buying of that house. Is that gonna be a problem?
Yeah, if you don't have a buyer broker.
Buyer broker,
agreement.
yeah, okay. I mean, okay.
Right, because because what the problem you create for yourself is you've created a fiduciary duty for yourself without compensation,
Okay.
right? So, and that's why I said there's going to be a lot of litigation. Because then if you decide to say, look, Mr. Buyer, if you're not going to pay me, I'm out of here, right? And then the buyer ends up closing on the deal anyway, and then the deal goes sideways, right? I get to sue you for breach of fiduciary duty for walking away from it.
Yep.
Right? And your answer is like, well, I didn't get paid. It's like, I don't care, right? You created the duty and you failed to fulfill it, right?
Okay.
The fact that you didn't get paid was your fault, not mine.
So there's gonna be no ethics issues. I mean, that's separate from legal, of course, but we've always been told that the client comes first, no matter what the commission is, take care of the client. Don't try to come back and ask for more money when it could screw up the whole deal. But it sounds like, okay, with the buyer broker agreement, I guess it goes back to that.
Right. I mean,
agreement.
I think what's going to happen is agents are going to get stuck in this position where they're forced to work for free because they didn't work out their comp ahead of time.
And last question, do you think you've read the buyer broker agreement? Do you think it's a little more complicated than it should be? Could it be, could it be made simpler? I guess is the question.
I've told this joke before. My father got into real estate in the 70s, right? And he jokes
Good old
that
days.
his first deal, right? The contract was 3 pages long, right? Now and the whole transaction was like 9 pages long, right? Now the contract's 18 pages long and the whole transaction is 200 pages long, right? And his joke is, you know what's happened in those 30, 40 years, right? Lawyers got involved.
Yep.
The deal's the same. It's the same house.
Thank you.
Right? I mean, yeah, it's complex. And now the fact that you guys are going to have to use it more, it's going to get longer.
That's
Right?
crazy.
I'm sure Rossi's at his desk right now rewriting the buyer broker agreement. It's going to be 4 pages long next year.
Okay. Thanks, Anthony.
I got another Zoom question.
It's
Um,
not Ron, is it? I just mentioned his name.
What can these damages do to NAR?
I mean, my understanding is it could bankrupt them.
So I want to say, if I'm the listing agent, if the seller doesn't want to pay the buyer agent the commission fee, but if a buyer comes in, asks me to write offer, I will be asked the buyer to sign the compensation, the form. I don't want to work for free with the liabilities involved.
Correct. All right. Well, thank you, guys. I'll hang out for a bit if anyone else has more questions.